you ever wondered, how are Bursa Malaysia's marketplace being monitored? Would you like to know how the marketplace is maintained orderly and fair? Welcome to Bursa Malaysia. We are the frontline regulator of the equity and derivatives markets. So, what does this mean for you? Through Bursa Malaysia regulation, we ensure the markets you invest in are orderly and fair, so that you have timely, accurate, and complete information to make informed investment decisions, are able to trade in a fair and efficient environment, have confidence in your brokers to provide secure and trusted services to you. So, how do we protect the marketplace? We have multidisciplinary teams in Bursa Malaysia regulation that focus on specific areas while collaborating with each other to provide a comprehensive network of safeguards for investor protection. We also work closely with other regulators and law enforcement agencies. Real-time surveillance of the market. We have a market surveillance team that acts as your market police. They monitor the stock market against irregular trading activities in day-to-day trading. This team uses an automated surveillance system to monitor trading in the equity and derivatives markets in real time. Should irregular trading activities be detected, this team of specialized analysts will fact-check and engage the brokers involved for their immediate action. Supervision of intermediaries. As safeguarding the integrity of the marketplace is paramount to us, our intermediary supervision team secures the protection of your trading and deposits through consistent broker monitoring and inspection. Disclosure. Continuing listing obligations and gatekeeping of listed companies or products. To be ASEAN's leading, sustainable, and globally connected marketplace, Bursa Malaysia places high emphasis on the quality of our listed companies. This begins from the approving of new listings on the exchange, through to ensuring that listed companies remain of quality through governance and compliance, as it is imperative for investors to be well informed in the fast-paced financial world. Bursa Malaysia regulations listing and corporate surveillance teams monitor companies' corporate announcements so that they are disseminated to you in a timely and accurate manner. Enforcement action is taken should there be any failure to do so, or should there be any material inaccuracies to the announcements made. As we are also a venue for listed companies' secondary fundraising, our relevant departments work together to ensure investors' funds are always used as mandated. We have a dedicated team of finance experts to examine corporate disclosures, including financial reports, so that they are accurate and timely that you can rely on. Within Bursa Malaysia regulation, we have subject matter experts that look at the various international sustainability reporting frameworks that are constantly evolving to ensure that our disclosure requirements are appropriately benchmarked. This ultimately drives the desired improvements in our PLC sustainability disclosures as well as practices. Taking enforcement action. So what happens when the persons are regulated by us? Be they brokers, advisors, listed companies, directors, or their representatives, breach our rules. Appropriate action will be taken against them. The types of action taken would depend on the severity of the breach. Suspected breaches will be investigated, and enforcement actions will be taken if the breach is proven. Our enforcement proceedings and actions are consistent and fair as cases are discussed in a robust manner through our regulatory committees, comprising independent individuals with relevant experience and backgrounds. Policy and rulemaking. Bursa regulation is the guardian to the 10 rule books of the securities and derivatives markets. Rules drawn up by the regulatory policy and advisory team are always outcome-focused. Industry or public consultations with the relevant key stakeholders will be undertaken, alongside rigorous benchmarking processes to ensure the rules are relevant, effective, fit for purpose, and on par with international standards. Each multidisciplinary team in Bursa Malaysia regulation is intertwined and interact proactively to ensure high standards in market integrity.
Good afternoon, everybody. Good evening, everybody. Welcome to this session that's titled Introduction to Hibah and Hibah Amanah, brought to you by Bursa Malaysia and managed by our company LifeChamp. In our webinar today, we're going to talk about Hibah and Hibah Amanah. So my name is Shen Chu. I'm the moderator for this session. Now, before we begin, as usual, disclaimer, whatever we share in this session is only for educational purpose. In no way that we give any recommendation for you to buy or sell any listed securities that we mentioned here. Should you decide to make any investment decisions, you are solely responsible for all your investment risk. Now, allow me to briefly introduce our speaker today. He is a partner at Raja, Darrell and Low and heads the Islamic Finance Practice Group. Professionally, he is qualified as Chartered Professional in Islamic Finance. He is an EXCO member of the Association of Sharia Advisor in Islamic Finance Malaysia. He is also a member of the Ethics and Compliance Board for the Malaysian Financial Planning Council. Previously, he served as Honorary Secretary and a Grand Council member of the Chartered Institute of Islamic Finance. He currently sits on the Islamic Finance Committee of the Malaysian Bar Council as the co-chairperson. So he's none other than Dr. Shaikh Adam Al-Habshi. So, Doctor, how are you today?
Great.
All right, so pleasure seeing you today. So we can't wait to learn from you what exactly is Hibah and how we can utilize it. All right, so over to you, Doctor.
Thank you, Shane. Feeling a bit hungry though. 8:30. Still haven't had my dinner. Didn't dare to take my dinner before the talk.
All right, so we quickly finish it and then you can go and have a quick bite.
So we are stopping at 9:30 for Q&A. Is it?
Yeah, that's right.
Right. Great. Let me just share my screen.
But you may go longer if you need to, because if you have a lot of content, you can go longer. We can cut short the Q&A.
Okay. Am I sharing the right screen, Shane?
Yes, perfect.
Okay. Thank you again, Shane. Thank you again for arranging this talk. My name is Syed Adam Al-Habshi, and today we are going to have an introduction talk about Hibah and Hibah Amanah. Just change the slides. Okay, it's working. Right. So when we talk about Hibah, what we're going to cover is the definitions, some of the characteristics of Hibah under the BNM Bank Negara Malaysia policy documents. We're going to talk about Hibah, the composition, what constitute Hibah, Hibah assets, what constitute Hibah assets. We're going to talk about the effect of Hibah and possession or qabat of Hibah assets. And then the use of Hibah in Islamic finance, as well as the distinctions between Hibah, Hadiah, and Sadaqah. Thereafter, we're going to move towards Hibah Amanah. We'll talk about the definitions, we'll talk about the benefits, application, the issues, as well as some national land code restrictions. And then we're going to talk about some of the products available in the market on Hibah Amanah, ASNB, Tabung Haji, and well, the whole idea of Bursa having this talk is to talk about the Hibah of CDS accounts. That one I will try to explain a little bit about that, so that if you have a CDS account, then you might want to consider having a Hibah Amanah product for that particular CDS account. Right, without further ado, let's start with Hibah. The definition of Hibah or gift. From the linguistic perspective, the Hadiah is also an Arabic word which forms the word Hadaya or guidance. This is the definition of Hadiah. Why I talk about Hadiah? Because there's always a confusion between Hibah, Hadiah, and Sadaqah in Arabic. In Malay, we usually use the word Hadiah. Hadiah in the terms of gift, or in English we call it gift, right? So Hadiah is actually an Arabic word, comes from the word Hadaya, which means guidance. So from the Sharia perspective, when we say a person has guidance, then we say he has got the Hidayah, which comes from the word Hadaya, and you can derive it as a gift from Allah, from God. From the common law perspective, there are three types of gifts that are categorized as gifts. These are the definition taken from a case law called Li In Chin versus Gan Yu Chin. It is funding or transferring of an asset outrightly. That means you outright transfer the asset. It also constitute complete transfer of assets to the trustee as a trust for beneficiary. That means you gift, you settle or you become a settlor and you depart from the beneficial and the legal ownership of the asset to a trustee who then holds it in for the benefit of the beneficiary. So I always tell my team when we talk about ownership, there's always the idea of legal ownership and the beneficial ownership. We call it internally we will call it the LOBO, legal ownership and beneficial ownership. So if you outrightly transfer these two ownership to, you can transfer it either to one person as an outright transfer. It means I transfer it to Shane directly, or I can transfer the legal ownership to Shane, who then holds it for the benefit of a certain other list of beneficiaries. So the beneficiaries will have the beneficial ownership and Shane will hold the legal ownership. So I've created a trust. So a complete transfer of assets to the trustee as a trust for the beneficiary is also a categorization of a gift. A complete transfer of asset by owner who declares himself to be a trustee to the beneficiary. So instead of I transferring it to Shane, I transfer it to myself as the trustee and I hold it for the benefit of Shane. So I become the law and Shane will get the bow, legal ownership and beneficial ownership. So in terms of Hibah, is also an Arabic word, which the root word is wahaba, which means to give or gift, right? Kamus Dewan defines it as voluntarily giving of rights or assets to others with a good purpose. From the Sharia perspective, is scholars have said that Hibah and Hadiah are more or less the same because both are derived from the same hadith. Exchange Hadiah as it will increase love towards one another. See the Arabic, the hadith in Arabic, it says tahaddu tahabbu. If you give gifts, then it will increase love towards one another. It's a sunnah to give gifts to people because it will create more love among one another. And we do that, right? In our daily lives, like for example, for birthdays, some say that we are lucky to have birthdays, annual birthdays, because if not, then we would be expecting gifts every other day. Now we have birthdays, so you can expect gifts only once a year. The idea of Hibah is there's also the addition element of the intention. The intention is very important from the Sharia perspective because intention can be good, but for example, you can do a wrong thing or you can do a right thing but with the wrong intention. That's not right. For example, you can pray, which is a good thing to do, prayer, but the intention is to show off to other people. So that's doing a good thing, but the intention is wrong. So then it becomes a bad thing. Or you can do with the right intention, but you're doing a wrong thing. For example, if I feel that Shane is hungry and I go and immediately force him to eat food, that's forcing him is for his own good, but forcing him is a wrong thing, even though my intention was right. So you can do a bad thing with the wrong intention, still not good. You can do a good thing with the wrong intention, it's also not good. You must always do the right thing with the right intention. Then it completes. This exchange hadiah, as it will increase love towards one another. One of the lessons from my Sharia teacher is that if people were to learn about the religion properly, then a lot of people would be having a tough time. Because, for example, in a husband and wife, if the wife knows her rights under the Sharia and the husband is not educated in the Sharia, then it will create a hard time. Because once you know the rights, once you know things that you are supposed to do, what you are encouraged to do, and if you don't do it, then it creates a bad situation for the relationship. So if the husband knows about this hadith, exchange gifts as it will increase love towards one another, and he continuously showers to his wife gifts and everything, then the wife would be the relationship would be a happier relationship than if the husband doesn't know and doesn't give gifts. But if the wife knows and expecting the husband to do it, and then you get the problem. So both must be educated from the Sharia perspective. Characteristics of hibah under Bank Negara Malaysia policy document. So we have Bank Negara, the Central Bank of Malaysia. They have published a policy document pertaining to hibah or gift. And one of most of the things that is derived from tonight's talk is actually in relation from this Bank Negara policy document, because it gives a very comprehensive description about what a hibah is. It says that hibah is a benevolent contract for the unilateral transfer of ownership of an asset from the donor or the wahib to the doni mawhub lahu without any consideration. In other words, it's a unilateral contract. From the contract law perspective, it's a unilateral contract. You don't need an offer and acceptance. You just need the offer of a gift from a donor to the donee, and there is no need for any consideration. So I can give Shane a gift and I don't expect a consideration. Consideration means a counter value that is being given in relation to the exchange of assets. So if I want to sell Shane this pen, then I put a price of RM1. When I give it to him, to Shane, this pen, Shane will pay me RM1 as a consideration. That's a sale. That's a unilateral contract. But a hibah is a unilateral, that's a bilateral contract. A hibah is a unilateral transfer or unilateral contract where I give this pen to Shane without any consideration. Of course, from the legal, from the stamp duty, if you're talking about gifting of gifts like property or land, then if a mother can give a gift to the child without any consideration, and then but it will still attract some form of a stamp duty. That's a different tax that is being imposed upon the hibah. But to create the contract, to create the hibah, you don't need to have any consideration in relation to the transfer of the asset, right? And the hibah may be revoked by the donor if there are certain conditions. The donee takes possessions of the asset. Before you can revoke a hibah before the donee takes possession of the assets or the fulfillments of the conditions in the hibah terms for a conditional hibah case. So if there are certain conditions that needs to be met and for a hibah to be effective, and that those conditions are met, then you cannot revoke the hibah. But if before the conditions are met, you may still revoke a hibah. In Malay, sometimes they call it the buruk siku lah. You give and then you ask back for that gift. The peribahasa is buruk siku or ugly elbow. I don't know how. I still don't understand how the concept of an ugly elbow is when you want to take back gift from people, but that's the Malay proverb. Also, if I want to give, if I say, Shane, I'm gifting you this pen, and before Shane can take possession of the pen, I still have the power to revoke that gift. Another situation from the Sharia perspective is that a hibah from a father to a son may be revoked at any time, except when the ownership of the asset is already transferred to a third party. So I can give this pen to my son. He may have taken possession of the pen. I can still take back the pen until unless my son has already transferred the pen to a third party. So if he has given it to his friend, the pen he has given it to his friend, then I cannot revoke the pen anymore. And then also assets that are charged or subject to claims by a third party. So for example, if I give my son my shares of certain in a company, and then my son has taken a charge over those shares in order for him to take financing, and that means that asset has been encumbered, has been charged to a third party, then I don't have the right to revoke back that asset or that gift from my son. It's interesting that when Bank Negara wants to come up with a policy document, normally the step is that they will have a exposure draft being given, and they will ask for feedbacks from the industry. So when the exposure draft for Hibah, I still remember, I think back in 2013 or something like that, when the exposure draft was out, there was it did mention in the exposure draft that hibah from a father to a son may be revoked at any time. So one of the feedbacks that the industry gave to Bank Negara was in relation to what happens if it was a gift from a parent company to a subsidiary company. Does that mean that the parent company may revoke the gift at any time because of the relationship between a holding company and a subsidiary company? Father, son, parent, subsidiary. So Bank Negara actually responded to that feedback and said that for this particular requirement, it only applies to actual father and son, biological father and son, human father or human mother and a son, then only it's applicable. It's not applicable to legal entities such as companies, subsidiary to an holding company. This rule doesn't apply. The hibah rule only applies for actual father and son, or father and children, or mother to the children perspective. Right? What are the composition of a valid hibah? First, you must have the parties are the donor and the donee. Who are the donor and the donee? It can be natural person or it can be a legal entity. So it does when Bank Negara said that the revocation between father and son is not applicable to a legal entity, that is only in relation to that revocation. It is not in relation to whether a legal entity can give a gift or not. So in order to give a gift, a natural person can do it, as well as legal entities can also enter into this unilateral gift contract. And the donor must have the legal capacity to perform a benevolent act, and the donee does not need to have legal capacity. So for example, I can give a gift to my son who has not yet reached the age of majority, still a minor. I can still give him a gift. If there's no parent, if they don't have legal capacity, then parents or legal guardian may represent the donee. And then there must be an offer or an ijab. The offer must be there. However, the acceptance or the qabul is not a composition, as the hibah is a unilateral contract. So you can have for example, a gift to you can have an offer to give, but the donee doesn't need to expressly accept the gift, right? However, there are differences of opinion in the application of hibah within the Sharia court. As you can, there are some cases like Awang bin Abdul Rahman versus Shamsuddin bin Awang. The qabul is actually considered by the Sharia court as an important element. However, one may also argue that qabul or acceptance can be seen from the act of by the conduct of accepting of the asset by the donee. You don't need to actually expressly mention the acceptance. The action of taking possession can be considered as the acceptance from the donee. I see a question there. One example of hibah from father to son. Is it applicable generally from any parent, dad, mom to any child? Yes. The answer is yes. It's applicable to any parent, dad or mom to any child or son. So that there's some legal the Sharia differences of opinion, but the majority view is that when the hadith is from parent to a son, it also includes from the mother to the child as well, and also includes to the daughters as well. Now, hibah assets is also important. We'll discuss hibah assets in the next slides. What constitute a hibah asset? Hibah asset can be tangible or intangible assets such as intellectual property, goodwill or service. This kind of I think now in the YouTube there's a lot of quiz in relation to what is your love language, and some of it say that act of service is a type of a love language, right? So you can provide services as a gift to someone else, like a lawyer who does a case for pro bono, for free, to his client. Then that is actually a kind of a gift, but the gift comes from the form of his services, or goodwill or intellectual property. You can give your copyright or your trademark to someone as a gift. So it doesn't matter that the asset doesn't need to be a tangible asset, like a pen is a tangible asset, can also be intangible asset. It can be transferable or non-transferable assets. It can be shares or undivided interest. For example, in the land, you own you hold the whole land. You can give a portion of that land as a gift to someone. Then later on, you can the land office will then do the division of that interest. So it can be from shares or undivided interest. It can be either transferable or non-transferable assets. Any form of asset that, most importantly, number one, from the Sharia perspective, it must be recognized as a valuable, identifiable, and deliverable asset. And it must already be in existence and owned by the donor. So I cannot give something which I don't own yet or not in existence yet. So if I haven't bought a car, if I don't own a car, I intend to buy a car and then I want to give it to my wife, then that cannot be a valid hibah. I must own the car first, and then only I can gift it to someone. The asset must be in existence. It cannot be assets which have not, a car which has not been built yet. Cannot. However, assets to be received in the future by the donor may also be hibah assets. For example, if let's say I'm going to receive the gift in the future, the asset in the future, asset is already in existence, I'm going to receive it in the future, then I can give that to someone else. If the asset is still under a loan tenure, can it be hibah? So if we look back at the previous slides, you will see that you must, I think in the next slides, or did I mention it earlier? Encumbered assets cannot be given as a gift. So if I have a house, that house is being charged to a land for a particular financing, a home mortgage, then I cannot give that house to someone else. I need the consent of the third party who has a charge over the land. You need the consent. So it's not about whether the loan asset is still under loan tenure. It's more on whether the asset forms part of the security of the asset, of the loan, or the financing. If it forms part of the security, then you need the consent of the chargee before you can give it as a gift. So keep on asking the questions, then at least we have some form of interaction, because you can't turn on your video here. So what I'll do is I have this screen for the questions. As you ask questions, I will answer them as we go lah. Asset still under financing can be considered as not Hibah. I know that one is typo, because H and J is just side to side. Then you cannot transfer, you need the consent first. Once you get the consent of the chargee, then only you can do the Hibah, right? Hibah, when does it take effect? Hibah will take effect upon the donor or the guardian or the agent takes possession of the asset, fulfillment of the conditions for conditional Hibah cases, and the effect is that the ownership of the asset will then be passed from the donor to the donee. For cases where the Hibah is incomplete, the Hibah asset will be reverted back to the donor. So if I want to give a Hibah, but suddenly the Hibah asset is actually being charged to a bank, then the Hibah will, the ownership of the asset, even though I said I've gifted it to Shane, but then because there is a charge on the property, then the Hibah will not be complete. When the Hibah is incomplete, the ownership reverts back to the donor. A conditional Hibah must be based on conditions that is acceptable to Sharia. So I cannot impose conditions which are not acceptable to Sharia. So for example, I cannot say, for example, Shane wants to give me a gift, or I want to give a gift to Shane, and the one of the condition is that I want Shane to drink beer, a glass of beer, in order to make the condition as a condition for me to give Shane a gift. Although it may not be against the Shane's religion to drink beer or anything, but that condition is a prohibition from the Sharia perspective. So even that, so I still cannot give that condition is not an acceptable condition. The condition must be acceptable to the Sharia. There must not be any prohibition that blocks that condition from being fulfilled. So, for example, conditional Hibah on the death of the donor, that's an arguable condition, but it's from the Sharia Advisory Council of Bank Negara. It is allowed mainly for takaful perspective. Conditional Hibah on the death of the donor can be done there. Can I change the donee in the Hibah document? If you have already given it to the donee, then the Hibah is complete. Then you cannot change the donee until the donee accepts the gift. Before they accept the gift and the Hibah is complete, then you can still change the donee. Shane, I think Naskan's question also I've already answered live. Okay, next, effect of a Hibah is permanent. Any condition that limits the period of a Hibah shall be void and must not affect the validity of the Hibah. So I cannot put a condition that limits, I'm gifting you this pen for 5 days. Then after that, it will revert back to me. I cannot do that. Whenever I give, it must be permanent. There cannot be a condition that limits the permanency or the permanent status of that gift. Does the donee still need to distribute the proceeds from the takaful according to Faraid? That depends on the type of the takaful policy document that you have. If the gift is to the donee and the donee, then it doesn't form part of the estate. Normally, if it's a Hibah for takaful, it's been given to the donee and it forms part of the donee's estate. So then the donee doesn't need to distribute the gift to the donor's beneficiaries according to the Fara'id, because it's no longer the donor's estate anymore. It's now part of the donee's estate, or donee's possession or ownership. So you have to distribute it to the donee's estate, donee's beneficiary, not the donor anymore. Okay, good questions. Keep it coming. Possession is a very important criteria in a hibah actually. In most cases of a Sharia court, they will always check and see whether you have possession or not. Possession in Arabic is called qabat of the hibah. It shall take place when the donor releases ownership of the asset, release of the ownership through any mechanism permitted by Sharia, including customary business practices, and the donee has access to the assets or the authority to the asset and assumes risk over the asset as the owner. So is this idea of possession, like for example, I want to give a house to my wife, right? Or to my children. So the house, very big house, right? How does the court would look at the Sharia court would look at the possession is, does my child, my son, have possession over the house? So one of the ways to show possession is that my son has a key to access to the house. My son has done some form of renovation to the house because he acts like as the owner. He has done things where it shows like he is the owner. Those are the circumstantial evidence to show that possession has taken place. Possession can either be physical or it can be a constructive possession. For example, if I want to give shares to my child, right, to my son, shares it can be said to be an intangible asset because you don't see, except for last time we used to have a certificate of the ownership of the shares. Nowadays there's no requirement to have a certificate of the shares. So how do you show a constructive possession? Perhaps I can do a hibah deed where I say I'm giving you this gift, and by you signing below, it shows that you have taken possession of that gift. So that's a constructive way to show, or a legal way to show that possession has taken place. Because you can't give the gift like that. So you put it in a document, put it in a deed where the donee accepts the gift and says and declares that he has taken possession in the document. That will be a good circumstantial evidence to show constructive possession. Can donee reject the hibah? Yes, the donee can reject the hibah, because if not, then sometimes you also don't want certain things that been given to you. For example, an ugly bag that you really don't like, someone wants to give it to you, you have the right to reject it. But then comes from the Sharia perspective is the adab. What is the right way to reject a gift? The adab or the ethics of rejecting the gift is also that's a different discussion altogether. Perhaps you should accept the gift and then you can give it to someone else if you don't need it, because it's always encouraged to receive the gift because you want to honor the donor for giving you the gift. You don't want to hurt his feelings. I want to give Shane this pen. He says, forget it lah, that cheap pen he wants to give me. Then you want to reject it upfront. Then that's not a legal aspect anymore. It's more of the akhlaq. It's more of the characteristic ethics of living together. For example, in a society, you don't outrightly reject the gift. You may accept it. Then if you have no need or no use for it, then you can give it as a gift to someone else, or you can dispose it not in front of the donor, so that you jaga hati, you take care of the person's feelings. So that's a different aspect from a legal perspective, whether you have the right or you don't have the right. Yes, you have the right to reject a gift. Good question, that one. Because sometimes you do get certain ugly gifts as well. Maybe ugly in your eyes, or someone who wants to dispose his assets, but it's a very used asset. You also don't want to use it like someone wants to give you a second-hand shoes. You say, I'm not going to be using it. Then you can nicely say, perhaps someone else would have better use of the shoes. Or if you feel that that the donor really wants to have that feeling of, I have gifted something to you, then you can take it and later on dispose it by giving it to someone else, or you can sell it, or you can do whatever you want with the gift. The use of hibah in Islamic finance. So we have a lot of products in Islamic finance that uses the concept of hibah. Let's, for example, in binding ijara, you have this, I think, called wa'ad mulzim, where you can, at the end of the tenure of the ijara for, let's say, ITAP or hire purchase contract, sometimes the bank would use the hibah as a form of transferring the ownership of the asset to the customer. So instead of the customer having to pay for the asset, the bank gives the asset to the customer for free because he's finished the hiring aspect or the rental aspect of the asset. Then comes at the end of the hire purchase or the leasing financial lease facility, the bank may decide to give it as a gift to the customer. In takaful products, you can also have hibah. I think some of you have been asking earlier whether, and I've mentioned earlier as well in the policy document, as Sharia Advisory Council has got some rulings in relation to gifts for takaful products. In the mudarabah and the musharaka, as well as the wakala contracts, mudarabah is equity type of a structure. Musharaka is a partnership. Mudarabah is also a form of partnership. For mudarabah, the one party is the Rabbul Mal, or the provider of the capital, and the other one does the work. For musharaka, both parties contribute for the capital, and the partners can decide on who needs to run the partnership, etc. So how does the hibah come about is one of the partners may give his share of the equity to the other partner. So you can have that kind of gifts. Another example, which is not on the slide, is in relation to deposit accounts, right? So for example, you have a Islamic deposit account with a particular bank where the Sharia structure is based on qard or loan, where you loan your money to the bank, and the bank uses the money to do their business, etc. So normally in a conventional deposit account, when you put money in the bank, you expect to get interest in relation to that money. So it's always for deposit products to the bank, that is considered as a liability because the bank has to pay back. It's a loan with interest for conventional banks. For Islamic banks, we use different type of contracts. One of the contract that we use is a qard or loan, but in the loan, you can always see the concept of a loan agreement is that the creditor or the creditor cannot impose onto the debtor to pay extra or more than what the loan sum is. In a loan agreement, if I give 100 ringgit to Shane, then Shane needs to pay me back 100 ringgit. As a creditor, the one who is giving the loan, I cannot impose on Shane to pay me back 101 ringgit. Because that's interest, that's riba in Sharia, prohibited. However, Shane can voluntarily, without any influence or undue influence or force or contractual obligation imposed by the debtor, by the creditor, Shane can voluntarily want to pay more than what he has taken from me. So if Shane wants to give me 101 ringgit voluntarily, that 1 ringgit is halal. But if I impose that 1 ringgit to Shane, then it becomes haram, right? So I still remember when I tried to explain to my, I think it was when my daughter I think was still very young. I think either primary school or before primary school. She wanted to she was asking because she was seeing all these words of riba, riba, riba in the house from the books that as I was doing my research, when I was doing research on Islamic finance. So she asked me, Daddy, what is riba? So I had to explain to her. I said, if I give you 1 ringgit, then you have to give me back 1 ringgit. If I loan to you 1 ringgit, you have to pay me back 1 ringgit. If I impose any additional sum from that 1 ringgit, let's say if I impose 20 cents extra from that 1 ringgit when you want to pay it back to me, that is riba. But if you want to pay me 1 ringgit and 20 cents out of your own free will, then that's not riba. That is acceptable. So the riba element in the loan comes when it's forced by the creditor. So I thought I made it quite clear to my child, my daughter. Then I asked her, so what do you understand about riba? What is riba? And she answered with full confidence, riba is 20 cents. So then I left it there lah. So maybe to her the value is very important, but actually value is not important lah. Whatever the amount, as long as it's more than the loan sum, that is considered as riba. So for a deposit contract which uses the concept of loan, then how is the depositor going to make money if all banks are not going to give anything extra? No way would I want to put my money as a deposit to a particular bank. I'd rather put at another Islamic bank that uses a different contract where I know that I will be given some form of profit out of the money that I put in as a deposit. So Islamic, what happens is that Hibah is then allowed in order for the bank to give a gift to me as a depositor. So the bank will then give a Hibah to me, something more than what I have deposited into the account as a gift. And this contract is valid because I, as a creditor, the depositor in this case is the creditor, because I'm loaning the money to the bank. I didn't impose that rule. If the bank didn't give me Hibah, I can always take my money and put it in a different account, different bank. But I'm putting it there and I'm relying on the bank's discretionary right whether they want to give me Hibah or not. Normally, the bank would always give the Hibah because they need to maintain confidence level in with the depositors that, you know, you put it with us. I know we use a card contract, but we are good people. We will always give you Hibah, and our rate of Hibah is usually around this need, but we don't promise you, because the bank cannot promise you that they will give the Hibah, because the moment they promise to give, then you have the right to request for the Hibah, then it becomes haram. It becomes a riba. But if it's just a discretionary right, that discretionary obligation, not obligation also, discretionary of discretion of the bank to give the Hibah, then is considered as a Sharia compliant Hibah. Right, distinction between Hibah, Hadiah, and Sadaqah. In the context of its position in terms of Hadiah, Sadaqah, the term Hibah is used in general terms, which includes the meaning of Hadiah and Sadaqah. So there's a case of Pulimahi Rajeswari versus Mia binti Hussein, which is a Federal Territory Sharia High Court judge, Sharia Court decision. The Sharia High Court judge concluded that every Sadaqah and Hadiah is a Hibah, but not all Hibah sadaqah and hadiah. These are actually semantics lah, but I'm just going to go through it with you to show that there are some form of distinction. The only thing that distinguishes between these terms is the intention and the purpose of the donor. If one aims to glorify and honor the donee, then it is called hadiah. However, if the gift is intended to draw closer to Allah subhanahu wa ta'ala and expect the rewards alone, then it is known as a sadaqah. So in Harun bin Musa versus Manda binti Mamad, in this case, the judge from Terengganu Sharia High Court, in his judgment, he described the distinction very clearly, the distinctions between hibah, hadiah, and sadaqah. So the distinctions are as follows. Giving to a person for the sake of honoring him with ijab and qabul, offer and acceptance, it can be either a hadiah or a hibah. Giving to a person neither for the sake of reward nor for honoring him with ijab and qabul is only a hibah. Giving to a person in need without ijab and qabul is sadaqah. So if you see a beggar or anything, you give some money to him without he is a person in need, but you give it without saying ini hadiah, ini sedekah saya, and then the fellow say saya terima sedekah ini. There's no offer and acceptance. That is sadaqah. And the best way of sadaqah is to give something with your right hand that even your left hand doesn't know about it. That's sadaqah. Giving to a person in need with ijab and qabul, that means I'm giving it to you. You are a person in need. I'm giving this to you. And then there is offer and acceptance. Then it is sadaqah and hibah. Giving to a person for the sake of honoring him without ijab and qabul is hadiah. So if you give a gift without the offer and acceptance, then it is just a hadiah. With offer and acceptance, it is hadiah and hibah. So hibah is always associated with ijab and qabul, or the offer and the acceptance. The sadaqah element is more in relation to when you want to do it something for the from Muslim perspective, with the idea of reward from God. Of course, all hibah, hadiah, and sadaqah is a good act, is a good deed, and you will get reward. But if you are doing it with the intention to get just the reward from Allah subhanahu wa ta'ala, then it's a sadaqah. Right? See, no more questions already. Is it too deep, is it? So that's generally the whole concept of hibah. How an Islamic bank set the interest rate to be charged on housing loan while avoiding riba. Okay, well, this is not a question of hibah, but I'll just answer it briefly. The Islamic bank, they don't charge interest. What they do charge is profit rate. So it depends on the type of product. Normally for housing financing, we don't call it loan because it's not a loan, it's a financing. Pembiayaan. So in a house financing, normally there are different types of products. Of course, the rate that the bank will impose on you is based on the base financing rate, on how much is the cost of fund what is the cost of fund that they have to incur. Then they want to make some profit out of it. So let's say they take the depositor's account. So from the deposit, they know that, for example, very briefly, they have to pay 1% to the depositor. So then they will impose a higher financing rate. Of course, Bank Negara will give the base financing rate, and then they will add on the cost of fund over and above that. Bank Negara sets the profit rate and the interest rate for conventional banks to all the banks in Malaysia. You have to follow that base financing rate. Then you can impose the bank's cost of fund as well onto the financing. So, and that form of cost of fund depends on how much is the cost that the bank has got to incur to get the money to give it to you. That's how they would usually in a nutshell, how they determine the rate of financing to be given to you. Now, Hibah Amanah. Hibah Amanah, you have to how to understand it is that it is a hibah, but there is the element of trust built in it, right? It's a wealth management instrument that involves the appointment of a trustee who is responsible to maintain and manage the trust property according to the terms and conditions set by the donor. A Hibah Amanah is a hadiah by the donor during his lifetime, where the donor may still use the asset even after the Hibah Amanah has been validly effected. So for example, I do a Hibah Amanah for a particular asset for a beneficiary, for a donee, but the structure is that there is the element of trust in it, where even after I've given the gift is a valid gift, but I still have the right to use the asset for as long as I live. So there's the trust element that is being embedded into the hibah. Hibah Amanah cannot be revoked unless a revocation clause provided at the time of the time the Hibah Amanah is made. Why? Because it has the number one, Hibah of course cannot be revoked, right? Unless the conditions that I mentioned earlier at the beginning of the presentation. But because it has the element of trust in it, right? It's the same concept like a living trust under the common law. So therefore, you can have a Hibah Amanah and you can provide a clause to revoke the Hibah. So when you revoke the trust, then the Hibah disintegrates and the ownership will go back to the original donor. So Hibah Amanah property will return or swing back to the donor if the donee dies before the donor. So what happens in some of the Hibah Amanah product is that, for example, there's a difference between a conditional gift and a gift with condition. A conditional gift is that I need to fulfill certain conditions before the gift is effected. A gift with condition is that the gift is already effective, but there are other conditions that needs to be met. So Hibah Amanah, there is a condition for some Hibah Amanah product. For example, I give my house to my daughter, right? But I put a condition, the Hibah is effective, my daughter now owns the house. But there is a condition. The condition is that if my daughter dies before me, the house swings back to me. If I die before my daughter, then the Hibah is already effective. My daughter is the owner of the house. So that's the general understanding of what a Hibah Amanah is. When we say Hibah Amanah in the market, is a situation where upon the death of the donee, if the donee dies before the donor, the asset swings back to the donor. From the conventional perspective, this kind of gift is okay, no problem. But from the Sharia perspective, there is Sharia issues there. So for example, there are various differences of opinion between scholars on the validity of this condition of swing back factor, because they argue that, as I will explain later, the benefits of a Hibah Amanah is a good wealth management instrument. It will avoid the use of inheritance law, hukum pusaka, or the faraid against the Hibah Amanah asset, because the asset has already been Hibah. The donor still holds the right and benefits of the Hibah Amanah asset during his lifetime. This reduces the risk of losing the assets during life. It speeds up the process of estate distribution because it no longer falls under the category of the estate of the deceased. It's already out of the estate of the deceased. It allows the donor to choose the donee and beneficiaries of his estate before his death. So instead of relying on the hukum pusaka or the faraid laws or inheritance laws, then by doing a Hibah Amanah, you sort of like trump the faraid because you are now choosing your beneficiaries. So that choosing who wants to be given with your asset during your lifetime is all entirely up to you. You can give any gift that you want to anyone that you want. So when you, with the Hibah Amanah, once you've given it to someone, then that's their gift. That belongs to that person, and so it doesn't form part of the donor's estate. So when you die, it's easier it speeds up the estate distribution because that asset is no longer part of the estate distribution. What happened to Hibah asset if donor and donee die before Hibah asset transferred to the donee? Well, certainly, that's a, how do you answer this question? So there is a Hibah, donor and the donor has given a gift to the donee, and then both of them die before the Hibah is being transferred to the donee. That means before the asset is transferred to the donee, both of them die. If the donee dies before taking possession, then the Hibah is incomplete, so it will go back to the donor's estate. It doesn't matter if the donor has already passed away, then it will still fall under the estate of the donor because the gift is not completed. It's a good trick question, that one. Hidayu. Took me a while to capture the context of that question. Can the asset that is to be given through Hibah Amanah include a variable? For instance, a sum of money in a bank account which may increase. Yes, it decrease at time of death. So you can do a Hibah of that's why for CDS account also you can do. You give the account and all its content. So the gift has already been passed. So because of the Hibah Amanah, the gift has already been effective. But you have the right to use that gift. So the value will go up and down, etc. And then if the donor dies before the donee, that's it, finish. If the donee dies before the donor, then the swing back factor will kick in and the Hibah, the ownership will go back to the donor. So again, as we look at the next slide, there are some this Hibah Amanah with this swing back factor is not a smooth sailing opinion. There are some differences of opinion between scholars. What if both donor and donee die together in an accident? Good question. Then you have to look at, there's an act which there is a statute that talks about this. If you really cannot identify who died first, then the law would presume that the older one died first. So if a father and a child were in a car accident and there's no way to identify who died first, then the law would presume that the father died first before the son. How Hibah Amanah speed up process of estate distribution comparing against a will? Well, if the asset is under Hibah Amanah, then it doesn't form part of the estate. So you don't need to consider it as part of the estate distribution. So then if you have Hibah Amanah all of your property, then when you die, there's nothing to be distributed. Only maybe certain things that you have left that you have not distributed. Those will form part of the estate. So that one, it speeds things up in terms of estate distribution. And it's normally if the proper Hibah is done, then the administrator can easily do the transfer of the ownership without having to look at the faraid or the list of beneficiaries. You can or the how many portion does the son get, the daughter gets, etc. Because that house is not part of that equation. The administrator will look at the Hibah deed and see that the house is being Hibah to the son. Then the administrator will just fill in the Form 14A or do the necessary legal instrument in order to effect the transfer. Now, appointment of a trustee in the form of agency. So you in a Hibah Amanah, you have a appointment of a trustee. The trustee will administer and manage the property in accordance with the terms that are sealed. The term may entitle the grantor of Hibah Amanah to use the Hibah Amanah property for its own benefit. The Hibah Amanah is a combination of Hibah and trust. Hibah Amanah is different from Faraid and Wasiat. Hibah Amanah assets are no longer considered part of the estate of the donor. Legal fees for Hibah don't have to pay under Faraid. No, still have to pay. There are still, if you want to do transfer of the conveyance of the estate, there's still legal fees. But it makes it easier for the lawyer to do it. So there's still fees. Don't say that the Hibah Amanah will make lawyers like me lose out on fees. Yes, we still charge fees when we want to do the administration, etc. Issues of Hibah Amanah. Contrary, the scholar says it is contrary to the concept of giving Hibah, which is when I want to relinquish my rights and benefits from a property during my lifetime, I want to give it for good. I give it to my son, that's it, finish. I don't want, by having this Hibah Amanah, whereby there is this idea of if you die first, I want to get it back, then it defeats the wisdom of giving a gift. A gift should be forever, and once I've given it, it's no longer my estate or no longer my asset anymore. I've given it to you, that's it, finish. But when you impose this Hibah Amanah, it's like at the back of your head, I don't want to give it 100%. Only if he dies, if the father may think, oh, if I give it to my daughter now, if she dies, the house or the car will go to the husband. I don't want the husband to get the house. Since I'm still alive, give it back, come back to me so that I can give it to my other child. I don't quite like the husband, my son-in-law, for example. If you have that, then it defeats the wisdom of giving a gift, if you look at it from one perspective. Another argument against Hibah Amanah is that scholars look at it as trumping the Faraid laws or the Wasiat laws. So it's like you're saying you want to move around, you want to beat Faraid by having this Hibah Amanah. So it doesn't look good because Faraid is already a perfect way of distribution of estate. Now you want to think you're better than God, is it? Some people argue it like that. Breach of stipulated time limit to effect Hibah, whereby the true concept of Hibah should be carried out during a lifetime. So Hibah is allowed because you are the owner of your asset, of your possession. During your lifetime, you have all the rights in the world to give it to anyone you want. The moment you die, this ownership of the asset, of all your wealth, your property, everything, it all goes back to God. But God then transfers it back to the administrator, no, not to administrator, transfers it back to the selected beneficiaries according to Faraid. So when you do this swing back upon death, it's like you are saying you are still having control over your asset after your death. That's why scholars are very much against it. There's also conflict of jurisdiction between equity and trust is a federal jurisdiction. Sharia trust is a state jurisdiction. So there's always this dispute between which court should be regulating or should be hearing or enforcing a Hibah Amanah. Is it a trust or is it an Amanah or is it a Hibah or is it just a mere living trust? So it creates a conflict of jurisdiction, and it can create for good argument for both sides. So those are the issues against Hibah Amanah. Restrictions in National Land Code. This one is it's a very interesting two cases. Land ownership through the concept of Hibah There's a Form 14A without any consideration, but still have to pay stamp duty. Nevertheless, for Hibah Amanah cases, there are two cases in the civil courts that have decided differently. In Salma binti Omar 2012 case, the concept of joint tenancy was rejected by Justice Zakaria Sam. He said that it's contrary to Islamic teachings because ownership rights cannot be restricted only during life. There is an element of gharar in joint tenancy. The doctrine of right of survivorship could not be applied to Muslim inhabitants in the Strait Settlement where their personal law did not allow for creation of ownership limited in time. But then in another case, in Peter Chong, Salma's case was distinguished because it was not an inter vivos gift case like Peter Chong. Peter Chong was about joint tenancy, and the court decided the concept of Hibah Rukbah, which is similar to joint tenancy, and Hibah Rukbah does not contravene Sharia law. So there's no element of gharar in Hibah Rukbah. So these are two civil law cases that tried to hear a Hibah matter. When Hibah is also a personal law or personal matter, it should go, one may argue that it should be heard in a Sharia court. So why does it appear in both courts? Because of the conflict of jurisdiction that I mentioned earlier. So some say that in earlier, the pros about Hibah Amanah is that it may make it easier for estate distribution. I know there was a question earlier, I didn't want to say it then. But the counter argument is that because it may lie in either one of the courts, people may argue that it's civil court, it's Sharia court, etc. So it may adversely affect the estate distribution and make it even worse. I'm not here to as a proponent of Hibah Amanah or supporter or anti Hibah Amanah. I'm here to share with you what are the introduction of this concept of Hibah and Hibah Amanah, and I'm here to show you that there are pros and there are cons on Hibah Amanah. ASNB has got a Hibah Amanah. They have done it. So you can do your Hibah Amanah of your money or your equity or your units of the trust fund in the ASNB. You have to pay a certain amount to appoint ASNB as the trustee of your account. Then upon your death, ASNB as a trustee will then distribute the money, the units that you have. It's not money, it's not a deposit account, it's a unit trust account. But it's pegged to 1:1. 1 unit is 1 ringgit, so it's easy to calculate. So upon the death of the donor, the donee will immediately get the units in the trust, in the ASNB account. Interestingly, after the Hibah, there is a clause, I think there is a the waiver of, not waiver of rights, there is the donee gives the donor the right to continue to use the sorry, my mistake for eating twisties just now. It's catching my throat. So moral of the story, don't eat twisties before you give a talk. So upon the lifetime of the donor, he can still use the unit trust. Only upon his death where the trustee will then transfer the asset to the donee. That's ASNB's structure. So it depends on the Sharia committee of that institution. So ASNB Sharia committee allows for Hibah Amanah to be a valid Sharia product, right? But if you look at Tabung Haji also has got a Hibah Amanah. The Tabung Haji Hibah Amanah is a bit different. The giver of the Hibah Amanah is free to grant Hibah Amanah property owned to whoever the intended recipient, including non-Muslims individuals. So I can put my money in Tabung Haji, and then I can hibah it to anyone, including non-Muslims. The granting of hibah amanah is not subjected to faraid. Why? Because so anyone who is eligible to thus anyone is eligible to receive hibah amanah property. So I can give it to my legal heirs or non-legal heirs. Why is it not affected by faraid? Is because upon I execute the hibah amanah of my tabung haji account, the property is hibah in the perfect manner. A property that has been hibah in a perfect manner cannot be claimed by other heirs according to faraid law. Why? Is because it's an outright gift. I have already gifted it to the beneficiary, to the donee. It's now the donee's right to the estate. So if the donee dies, that account is subject to the estate of the donee. It's no longer to the estate of the donor. It's an alternative or solution for the distribution of property for new relatives or converts who do not have Muslim heirs or adopted children. The grantor of hibah amanah can still enjoy the benefits of the property that has been granted as long as the donor and donee of hibah amanah are still alive. In other words, there is a way that the product allows for, if I want to give to Shane my tabung haji account, gift it to Shane, I can still use it. I can still use the money in the account. Shane can also use it. But the moment when, okay, let's not use Shane as an example. Let's say I give it to Mas Katun. There's a person by the name of Mas Katun. I give my tabung haji account to Mas Katun. Then Mas Katun can use the account. I can use the money. But if I die, it's already belonging to Mas Katun. But if Mas Katun dies first before me, the tabung haji account will be part of the estate of Mas Katun. So that's the difference. So tabung haji Syariah Committee didn't allow for hibah amanah like ASNB. They have a different Sharia view. So these are Sharia scholars who are well versed in their area, and they make their own ijtihad, or they make their own ruling based on their understanding. And for tabung haji, it's like this. For ASNB, it's like that. For CDS account, which is what Bursa is promoting, you have CDS account. So you can have, for Muslim investors, CDS account and the shares will then become the estate of the deceased and are the rightful heirs according to the faraid. So that means the beneficiaries are the rightful heirs to the CDS account, and it will be distributed according to faraid. So you can only go to Bursa. The administrator can go to Bursa and say these are the order to be distributed according to the faraid. However, on 17 November 2021, Wasiah Shop and then Awaris on the 8th June 2023 have launched the respective hibah amanah products for CDS account, where CDS account and shares will be owned by the donor selected beneficiaries through hibah amanah trust deed. So what happened is that I have CDS account. I can create a hibah amanah of that CDS account to whomever that I want, right? And then upon my during my lifetime, I can still transact and sell the shares of the account as usual. Only upon my death will then this CDS account and the content will be distributed to the beneficiaries that I have earlier on selected by Wasiah Shop or Amanah Awaris. So if you want to do CDS account, hibah amanah for CDS account, there's only two trustee companies that offer this product, which is Wasiah Shop and Awaris. So you can do your hibah amanah with them, whereby they will distribute the account, the CDS account, as well as the content of the CDS account to the beneficiaries that you have earlier on selected when you created the hibah amanah. It's a bit of the structure is a bit complex in the sense the Hibah Amanah for Awaris and Wasiah Shop is not a direct single Hibah. It's actually done with a double Hibah. I give to Wasiah Shop. Wasiah Shop gives it back to me. In the second gift, there is the element of swing back factor. If I die, then the asset will then be swung back to Wasiah Shop. So Wasiah Shop Sharia Committee, Awaris Sharia Committee, have come up with a Sharia pronouncement to say that this swing back factor is okay, it doesn't trump Fara'id. So, I mean, you can have people arguing here, there, etc. What is important is whether or not this, when it goes to the Sharia court, how will the Sharia court decide? So according to Awaris and Wasiah Shop, based on their experience, they say that the product, they've done their research, they are confident that the CDS account, even if challenged by the Sharia court, they will win, and the beneficiaries that the donor has selected will get the CDS account as well as the shares in the CDS account. So for example, you can also have a situation where you want to give it to someone who is not a legal heir. For example, if I have a stepdaughter, anak angkat, who is not my kin, not my blood, not from not my actual daughter, it's a stepdaughter that I've taken from a baby, I've raised her, she grows up, etc. So she, because it's a stepdaughter, she won't get any part of my estate. So I can do a Hibah Amanah, especially if I have a CDS account and the content, I can do a Hibah Amanah to ensure that she will get something from my property upon my death. So that's one of the beauties of this. Of course, you can also look at it from the negative perspective. If I have a wife and I have a girlfriend, I want to give to my girlfriend, also this can be done. But of course, I'm telling you all angles so that you are well informed and considered. But the noble idea is for, like, say, for example, your stepdaughter, or if you are a revert, you've entered into Islam, and your sisters or your brothers are still non-Muslim, then they cannot inherit from you because they are not part of the Fara'id system, because they are non-Muslims. Of course, you can do a will, 1/3 of your estate can be given to them. But also you can also arrange beforehand so that your CDS account and the content can be given to them, because you want them to be a beneficiary of your property. But this is not a beneficiary of your estate, because you have already given you have departed with the estate during your lifetime. But with the structure that Wasiah Shop and Amanah Awaris have, is a situation where you can still continue to use that do trading of the shares during your lifetime, and upon your death, then your non-Muslim brother or non-Muslim sister, or your stepdaughter, or your friends who are totally out of your family or Fara'id system, or your girlfriend, you can also do that and give it to them lah. So that's the Hibah CDS account for Muslims only. Non-Muslim can to make a will. Well, yes, and yes. So Hibah CDS account would only be for Muslim. Non-Muslims is easy because you don't have the restriction of Fara'id. You don't have okay, let me rephrase that. Non-Muslim are not bound by the Fara'id laws. So when you're not bound by the Fara'id laws, it means you can draft a will that says, for this property goes to here, this property goes to here, this property goes to here. Only the balance remaining, then it will be divided according to the Distribution Act. So if the will is valid, etc. Right? So you don't have to use the Farah 8 is not applicable to you. So you can just do a will. It's easy. In that sense, it's you follow the laws of the will, the inheritance according to non-Muslims. So you can do a will. That can be done. For Muslims, there is this element of Farah 8. Some people would like to make sure that they manage their wealth properly. So they want to do things during lifetime to ensure certain people will get certain properties. Good question. Okay, Q&A session, 9:50. Oh, I've
All right.
exceeded the because the questions keep coming. So
Yeah, I see that
kept
you have
on-
been addressing the questions along your presentations. And as a non-Muslim myself, I've learned a great deal about Hibah today. And I think by the end of your presentation, I received so much gift from you today, Doctor. I was quoted so many times. All right. So if you have any question to ask our speaker today, please write your questions in the Q&A box. All right. Now, Doctor, just now you mentioned about Wasia Shop and also Amanah Waris. So do you mean that they open a CDS account with a stockbroker first, then they bring their direct CDS account details to find these two issuers to package it as a Hibah Amanah?
So what happens is you must have an existing CDS account, and then once you have the CDS account, regardless if you have existing shares or not, doesn't matter. You can go to these two service provider, these two trustees, and you can check lah with them. I mean, I think more trustees are coming up with this CDS account Hibah Amanah, and the more that there is in the market, then the pricing will be more competitive. Then you can, if you select Wasia Shop, then you will follow the rules that they have prepared. You do the transaction, and then when it comes to once the Hibah Amanah is completed, what happens is that then you can continue to trade with your CDS account. Then let's say if by the time when I'm about to die, I have more than 5 million worth of shares in my CDS account. So those shares are the one that is going to be distributed to the beneficiaries. Even though I started the Hibah with a CDS account with no shares inside. Because what you Hibah is the account and the contents of the shares.
I see. Does it have to be a direct trading account, a direct CDS account, or it can be a nominee account?
I think it's meant for direct CDS account.
Direct CDS account. All right.
You have to probably check with Wasia Shop and Awaris.
All right.
I
The
think
next
nominee
question.
also can. I think nominee also can.
Okay. So better check with the issuer
Yeah, check with
for
the
accuracy. Right. What kind of document is used to obtain the chargee's consent for the Hibah of the charge asset? It's a
Okay,
question by Nas Khan.
that one you will have to check with the bank. So normally each bank has got their own style. Normally it's just a matter of informing the bank, and see from the bank's perspective, number one, as long as you are good paymaster, and even when you do the Hibah, they know that the credit risk is not much trouble, right? So you continue to make payments, etc. Normally they will allow for normal Hibah. So you change the ownership. You can check with each bank has got their own separate requirements. It's not a specific one document fits all. You have to check with the banks.
All right.
It's another one. SMB.
So what is the next question is, I think it is in reference to Tabung Hajis, where Tabung Hajis account can be given to non-Muslim. So the question here is, can an ASMB account be given to non-Muslim?
I'm not sure actually. I have not checked. That one you have to check with ASNB.
So the next question, which is perhaps the last question because we have overrun the session for a bit. What is chargee's consent? Could you explain how it works?
So a chargee's consent means it's just a consent by the bank in order to because they have a charge over the property. So I've given a financing, but I'm the bank. I've given a financing to you, Shane, right, for you to buy a house. So I give you money, let's say 150,000. You need 150,000, then you have to pay me back a certain sum with profit, etc. Sharia compliant transaction. Over and above that, to secure this facility, the house that you're buying, I will register a charge over the house. You will register a charge over the house for me. That means I will become the chargee. I get a charge over the house. Meaning, if you fail to pay the house, fail to pay the financing, then I can enforce the charge. I can go to the court and foreclose the house, sell the house, get the money, settle off the debt that you have with me, right? Because I have that power over the house, the encumbrance over the house, you cannot simply give the house or hibah the house to anyone. Because I have a priority over the house. I have an interest in the house. That's why you need my consent when you want to give it to someone else. And I will evaluate your request based on circumstances, specific circumstances. One of the things that I will check is that are you a good paymaster? So you want to give the house to your daughter, but you are a good paymaster. You can give me a different charge over a different property. Then I may allow you to give it to your daughter because you're doing wealth management, etc. I don't want to be a hindrance to that. So it depends on various permutation. I can't give a one size fit all answer. But yeah, that's how a charge is. I'm just checking the Hibah Amanah on ASNB. I think you can give to non-Muslim. For Muslim unit, oh no, this one is for Muslim unit holder. It doesn't mention. Maybe the person who asked the question can check with ASNB. But if you ask me from the theoretical perspective, there shouldn't be any issues lah. That if you want to give it to cuma they might want to request you to do a trust instead of a hibah amanah if it's for non-Muslims. I'm not sure. That you check with the service provider. I wasn't the lawyer who advised for hibah amanah for ASMB, so I don't know the direct details of that lah.
Yeah, I understand that, Doctor. So thank you so much for clarification. So that's all the time we have with Dr. Syed Adam on this session, introduction of Hibah and Hibah Amanah. And I did see many comments who say that this is a very informative session, excellent session. So thank you so much, Doctor, for spending your time with us today.
Thank you for taking the time to listen and not fall asleep. I apologize if the presentation is not as clear as possible. I tried to do my best, but because Shane put the timing at 8:30, so I'm hungry. So maybe that is the reason why my presentation is not that clear. So I apologize for that. And thank you.
Yeah, apologies, Doctor, for making you to skip your dinner.
Well,
Right.
just
So thank you everybody for staying tuned until the end of this session. So hope to see you guys again.